Hello, and thank you for joining our third annual Day with DISA. Before the session gets started, let's go over a few things. A copy of the presentation will be available to download once the session has ended under the Materials section. If you have questions about the information in this session, enter them in the Q&A section below, and the speaker will answer them once the session has ended. If we don't get to your question, we'll reach out to you at the end of the conference. If you have questions about the topics or trends that are mentioned throughout Day with DISA and how they pertain to your company, and you'd like to reach out to one of our team members directly, hit the chat icon at the bottom of daywithdisa.com and you'll be connected directly with one of our team members. Thank you for attending live. Each of our live attendees is eligible for our prize drawing at the end of the conference. And each session that you attend live increases your chances of winning either a Nintendo bundle or a brand new iPhone 12. Finally, I'd like to take this time to thank all of our sponsors for their participation in Day with DISA. Specifically, I'd like to call out CRL, our title sponsor for 3 years running. We'd like to thank our platinum sponsors, OraSure, Quest Diagnostics, Samba Safety, and Psychomedics. All of our sponsors' support is greatly appreciated. With that, let's get started. Enjoy your session.
Hello, everyone, and thank you for joining us for this session of Day with DISA. Today, we're going to be talking about an ATA safety regulatory update that obviously impacts everyone that's mandated by the DOT. Today, we have joining us Dan Horvath, the Vice President of Safety Policy for the American Trucking Associations. Comes with a wealth of experience from working with the ATA, with organizations inside the transportation sector, and even working with the FMCSA. Dan, thank you so much for joining us today.
Thanks, Thomas, for having me, and I appreciate the DISA folks for inviting me to talk about safety and regulations today. So hopefully we'll get some information out to you that might be new, give you a little bit of a lay of the land where we're at today, what we have coming down the pike, and certainly take some questions at the end.
Perfect. And Dan, you bring up a good point. If you have questions, do put them in the Q&A section at the bottom right. We'll answer as many as we can at the end of this presentation. If we run out of time, we'll circle back to everyone who asks a question after the presentation. Additionally, if you need to download the presentation, in the materials section at the bottom right, we will add a link to download the PDF of this deck after the presentation concludes. So when we're wrapping up, as we're starting Q&A, you can go download that presentation, and then we'll dive straight into questions. Dan?
Well, without further ado, I think we'll kick things off here. Kind of my goal today is talking about a lot of the regulatory happenings we have going on, primarily from FMCSA from a safety standpoint, which is what my team deals with at ATA currently. Certainly a little bit different of times recently with COVID-19, so we have some waivers and exemptions we'll go through, but really try and cover some ground in 30 minutes. A lot of information on the slides you'll see today, and I'll skim over a lot of that, but you'll have those as a reference to go back to if you do have any questions. So with that, kind of current lay of the land as far as COVID-19 waivers and exemptions go, and this is the beginning of October just because of how a lot of these were dated, but you see there on the screen we have a hazmat materials endorsement waiver that was actually set to expire October 29th. That's just recently been announced and extended through the end of the year, so that matches a lot of the other FMCSA related waivers. And the hazmat endorsement one was specific to the Transportation Security Administration, TSA, and their issuance of a security threat assessment background check. So if you need to have a hazmat endorsement, you have to go through a background check or security threat assessment. That is exempted through the end of the year, so extended. The second one on there, Hours of Service National Emergency Declaration. This was part of a broader emergency declaration that was really issued back in the beginning of March from FMCSA that extended a lot of different provisions of the regulations, primarily the Hours of Service regulations, if you are engaged in providing direct support for COVID-19 relief efforts, whether that be delivering medical supplies, food to grocery stores under emergency purposes, and other items related to COVID-19. I'll caution there's a little bit of a caveat with that exemption there. and primarily for the purpose of emergency response. So if you're a motor carrier, and in the course of your daily business, you're just delivering to grocery stores on a regular basis, you really need to clarify and preface that load, if you are going to utilize this emergency exemption, that load you are delivering is emergency purposes, which would grant you the use of that exemption. So I would say use caution with that one, work with your legal team. The last two on there have to do with some CDL related matters. The one on there, CLP holder accompanied by a CDL driver in the front seat. This has to do with a lot of bringing on of new drivers who have CLPs, when they can operate that motor vehicle, who needs to be, if they have to have a certified CDL driver with the commercial learner permit driving. Also has to do with some out-of-state skills testing. I won't get into incredible detail on that, but if you're engaged in training of drivers, this one might avail of its use to you and your operations. Second one, last one on there, CDL and CLP validity waivers. I think this one is the most significant to motor carriers out there currently. Basically, this extends your duration or your expiration period of either your CDL or your commercial learner's permit through the end of the year, through December 31st. It also extends your medical certificate expiration periods to either October 31st or through the end of the year to December 31st. So your medical certificates that expired between March 1st and June 1st, they would have expired at the end of October 31st, at which point you would have been required to renew your medical certificate. If your medical certificate expired after June 1st, you have until the end of the year to renew that medical certificate. This is all done basically on the availability of drivers to be able to get into medical examiners, to state driver's license agencies, and what have you, to renew those documents. So this is FMCSA's way of extending those waivers out and making the industry a little more flexible, so we don't have several drivers, thousands of drivers shut down on the side of the road because they were unable to renew these documents. And last but not least on the list, third-party CDL skills test examiner waiver that was extended through December 31st as well. So some of these on the slide may apply to you, some may not. I will caution you, if you are working directly with drivers, to make sure that they are checking with whatever state they are licensed in. There are some states that have not extended these expiration periods out, so they need to be aware of those. They need to make sure that they're checking on a regular basis to ensure that they comply with the rules and avoid any situations at a roadside inspection. The last COVID waiver I'll mention very briefly on the screen here. This was issued back in July, and this was guidance on random drug and alcohol testing, which might be very relevant to this group. And basically, it was from FMCSA saying if you cannot meet the minimum rate for random drug and alcohol testing, you should document the reasons why, and you will be found in compliance in the event of an audit at a later point. The kicker is in this last bullet point really summarizes it, if you are capable of meeting those requirements, you must continue to do so. So this isn't a end all to random drug and alcohol testing that says if you can't do it, fine. Really, the FMCSA is saying you should continue to test at the appropriate rates, 50% for drug, 10% for alcohol. And if you cannot get a driver in for whatever reason due to COVID, you should document that reason why. So this is one that I think carriers are really going to have to look with their legal counsel on to determine if this is something that they should utilize and how they're going to document those efforts in the event of an inspection or an audit, say next year, so that they can prove that they were in compliance at that point. So kind of shifting gears from COVID into our more of a regulatory update here. Everybody's always asking about electronic logging devices. So this is something that I do always like to cover. And the question is, are ELDs working? And from our perspective of ELDs and hours of service violations, they are working. This is a chart on your screen. It shows the compliance of hours of service rules. This was released by FMCSA. They update it on a regular basis. And you can see there that we've had a pretty significant decline in regulations from December 2017, decline in hours of service violations from December 2017, which is when ELDs really came into play, through December of 2019, which was the end of that grandfather period, to where we're at today. Certainly you can see there in the February-April timeframe, we had a pretty significant drop in violations. Would love to say that's all related to ELDs. Unfortunately, we know that's when COVID really came into play there. So we've seen a slight uptick, but comparing to where we were before ELDs were primarily being required, we've seen a significant decline in violations. So good news on that front. A lot of numbers on this screen. I primarily put this up there just to show viewers of the top ELD violations. So I update this about a monthly basis. This was updated at the end of September. There's about a month lag or so from when FMCSA reports these numbers. But these are the top ELD violations. That number one on there, record of duty status, RODS, violation form and manner. This was that old violation that existed for paper logs for not dotting your I's and crossing your T's and missing a city or state or what have you. Obviously, those numbers have gone down significantly since the use of the electronic records, so we're happy to see that. False report of driver's record of duty status, still have a significant number of violations for that, although it has trended downward since the previous year. Keep in mind that not all drivers are required to have an ELD, so you still have the potential for a false record of duty out there. The third one on there, no record of duty status. This would be when an ELD is required. The violations for 2020 so far, about 26,000 violations. And then the last three on there, or excuse me, rather the two on there, 24D and 22H4, these are violation codes. These change from month to month as far as how they rate. But the two in general are electronic log cannot transfer ELD records electronically. And then the other one, driver failed to maintain a supply of blank driver rods. Those are interchangeable. Again, they fluctuate from month to month, but these are common violations we're seeing. Another one I'll add that's not on this top 5 list, but that has been in previous months, is not having your electronic logging device mounted in a secure and fixed position. That's a violation that happens on there a lot. So again, a lot of numbers, but it shows you the comparison from month to month of where we're at with ELDs. And this last slide, I always include the bottom number on there, which is the number we're most proud of, and that is percentage of drivers stopped for an inspection that did not have an ELD when one was required, and that's about 1%. So the world did not end when we had ELDs come into place, as many had thought. Compliance, less than 1% for non-compliance is a pretty good number. So we're happy with that. We'll now look to see how ELDs are impacting crashes. Certainly, they're not going to fix all related crashes. They're going to address hours of service related crashes, fatigue crashes. So it'll be interesting to see where that data points us in the next year or so. So the big rulemaking we've been dealing on most recently at ATA is the hours of service rulemaking. It's been about a 2-year process, and by government standards, that's pretty fast actually to get a pretty significant rule introduced and implemented, and we are now in the implementation phase. Quick little history lesson going back to 2018 of when we had that first announced. It was an advance notice of proposed rulemaking, looked at 4 potential changes, included 2 petitions in there, received over 5,000 comments. There were multiple public listening sessions. And then about a year later, the notice of proposed rulemaking, which further refines that ANPRM, was introduced and covered 5 proposed changes. Another 3,000 comments from industry came in on that. A lot of driver comments, which is great. I mean, drivers are the ones using these regulations or governed by the regulations. Drivers should be weighing in and expressing their concerns. I say this joke all the time, but if you're ever interested, go on the docket and read some of these comments. They're public. The greatest ones are the ones in all capital letters with expletives and shouting at the agency through writing. And they're pretty interesting to read. This is a very important issue for drivers. So where we're at with the final rule that was introduced was announced May 14th, right in the midst of the pandemic. It was formally published in the Register June 1st, and then the effective date was June 29th. And it addressed these 4 areas of the hours of service regulations, which I'll go into very briefly here. So the 4 areas: short haul, changed around who is considered a short haul driver. And really the primary purpose of being considered a short haul driver is that you are exempt from record of duty status requirements. So an ELD in most cases. It expanded the radius of on-duty time and that air mile radius of which you could operate. Adverse driving conditions, this is something that's been on the books for a number of years, and modified that to also allow you to extend by 2 hours your on-duty time. 30-minute rest break, this was a relatively new rule that was introduced in July of 2013, or excuse me, June, July of 2013. And this was modifying that existing reg to allow you to take that time after 8 hours of driving time have passed as compared to after 8 hours of on-duty time. Also allows you to fill that break in an on-duty, not driving status, so you could be fueling your truck, doing what unloading, loading measures. Before you had to be completely off duty. Now you can be on duty, not driving. And last but not least, split sleeper berth. For those of you that use a sleeper berth or have trucks that have sleeper berths, you can now split your time a little bit more differently than you could before. Previously, you could split your time between an 8-hour and a 2-hour window. This now allows you to do a 7 and a 3-hour window. Both periods do not count against your 14-hour clock, which gives you a little bit more flexibility to rest and to avoid rush hour traffic and things of that nature. The bottom one listed here, split duty provision. That's highlighted. This was not included in the final rule. This was actually a petition from the Owner-Operator Driver Independence Association, OIDA. This was not included because there was a lack of data, as FMCSA cited. ATA raised some concerns with the lack of data. We did say, it sounds like something that could provide a benefit to industry. So let's pursue a pilot program. And lo and behold, a couple months after that final rule came out, a pilot program was announced by FMCSA. It's in the early stages, meaning it's not formally introduced yet. It's the kind of planning process behind it. But we look forward to seeing that come along and get us the data to see if this provision would make sense as part of the final rule. Couple follow-up comments on hours of service, just some common questions we get. There were requests from industry groups to have this hours of service delayed, the final rule. The most recent action taken in September was a lawsuit filed by a group of safety advocates, also the Teamsters. The lawsuit did not ultimately delay the September 29th effective date. Those rules became effective September 29th, but FMCSA is now in a legal battle, if you will, with these groups to determine whether those rules should be repealed or not. The bottom line, we have the new rules. FMCSA will work through that legal side of things, and hopefully these rules are here to stay. So shifting gears a little bit more and moving out of the hours of service ELD, compliance, safety, accountability, CSA more commonly referred to, is something I'm always asked about. I would love to get rid of these slides from my standard presentation. Unfortunately, it keeps coming up over and over again. Another little history lesson here. This goes back to 2014 when the GAO did an investigation and said, we really aren't sure that CSA is accurate in predicting crash risk for motor carriers. And that was really why CSA was created. It wasn't created to compare carriers from one another and allow business purposes to say what carrier is safer or another. It was really used to help FMCSA prioritize what carriers they need to provide intervention with, so to get involved before a crash happens. CSA is not doing that. The National Academies then did a report in 2017. They came up with recommendations. FMCSA about a year later responded to those recommendations and said, here's what we're doing to work on the system. And then most recently, the Office of Inspector General, September of last year, completed an audit of those corrective action plan to see where they stood. FMCSA has reportedly said we are pursuing what's called an IRT model, item response theory. This has been used in the medical field previously, not necessarily in transportation. And what this is this is the math behind the scenes. This is what powers CSA. This is what derives a carrier's score and allows that score to be used to determine if they are at risk for future crashes or not. So they had the SMS modeling before. FMCSA has been pursuing this IRT modeling to see if it's the right move. Just about a few weeks ago, FMCSA provided an update to ATA that they were still evaluating this. Part of the problem that we're hearing is that it may be a better alternative to the previous methodology, but it's really difficult to explain. I've heard the acting administrator or deputy administrator Wiley Deck say you need folks with lab coats to explain the math. And that's problematic when you're trying to sit down with a motor carrier and say, here's why you have the score that you have. The good news is FMCSA has not indicated that they're going to return the public scores anytime soon. we hope to see them work through these issues and get CSA out there, whether it's refined, whether it's the previous version that we have, that remains to be seen. I think, that we're not talking about CSA a whole lot these days, just because I think motor carriers are learning to deal with it and using it as is. So we'll be working with the agency over the coming months to determine what route they're going to take with that. Good news is, related to CSA, as part of it, FMCSA has expanded their crash preventability program. For those of you that are engaged in this is always a common complaint, is that if you were involved in a crash, whether you were at fault or not, that crash was put on your CSA profile. Again, whether your driver was at fault or not. FMCSA responded to that with a demonstration program. That demonstration program ended July 31st of 2019. And then in May of this year, a permanent program was announced that allows crashes to be reviewed. You have to submit a police accident report. If you do all of this and FMCSA determines that your crash is not preventable, they will mark it as such on your profile. Here are the 10 crash types. I'm not going to read through each one, but rather these are categories. So, for instance, struck in the rear or in the side at the rear of the vehicle. Previously, that used to be two separate types. That's been provided into one category now. The most interesting one on here, I say this one over and over again, number 10, rare or unusual crashes. And that's when the crash does not meet another crash eligibility type. I asked the agency, I said, what do you consider rare or unusual? And they said, skydiver landing on the highway and the truck runs over to skydive. I kind of chuckled, and they said that actually happened, was provided to us as an example. I felt bad after the fact because it was a sad crash. But they threw that in there for those truly rare or unusual crash types that don't meet these other categories. It's not meant as a catch-all be-all. So if your crash doesn't meet those other categories, you can't just send it into that number 10 and see if it sticks. It's meant to be pretty, limited circumstances which would meet that category. But the good news is a lot of common crashes that are not preventable from your drivers could fall into these categories. Allows you to submit the documentation and have it removed from that profile. So moving to drug and alcohol testing, some fun stuff has been happening here lately, and unfortunately not the best outlook that we have from our perspective at ATA, but one that we're working very fast to fix, and that's related to hair testing. So hair testing, as you all are likely aware, is not recognized by the Department of Transportation, which means if you want to do a hair test, conduct a hair test on a driver, you're allowed to, you can do that hair test, but you also have to do that DOT urinalysis testing as well. So it's side-by-side testing. We know that hair testing is much more thorough. It's much more likely to detect drug use than urinalysis. So you're going to be in cases where you have a positive hair test, negative drug test often, and that happens today. Just recently, earlier, about a month or so ago, the Department of Health and Human Services released guidelines that happened on September 10th. And these guidelines are the first step in DOT adopting hair testing as a regulation. So HHS writes the guidelines for hair testing. DOT then has to incorporate them into the rules. A lot of words on this slide here, but kind of giving you the high-level view of what those guidelines said. It said you would only be able to use it for pre-employment and random drug testing, which we're okay with from our perspective for hair testing. It's not necessarily beneficial in a post-accident situation because that urinalysis is more likely to determine or detect recent drug use, which is the purpose of post-accident, whereas hair testing would go further back in most cases. Our biggest concern with hair testing guidelines is this alternative specimen testing for positive tests. So how it would work under these guidelines, if you have a positive hair test, you would then be required to submit to a secondary alternative testing, which could be urinalysis or oral fluids. And we all know that those that are engaged in hair testing, you are going to have many, many situations where that hair test is positive and the driver goes in for urinalysis. Urinalysis comes back negative, and you are then required to report that urinalysis negative is basically the final test. The hair test would not be included. That's extremely problematic on our part. Main part is you would not be able to report that to the Drug and Alcohol Clearinghouse because it would be considered a negative test. Hair testing couldn't be reported. That's a serious concern, not just for folks that would want to adopt hair testing, but for folks that use it today. And this is all a result of HHS calling into question the science of hair testing, and they're really basing their claims off of just a few cases where hair testing was overturned in federal courts and state local courts as well as a result of it. So we are really working to fix this. We think that these guidelines as is would discourage wider adoption of hair testing. And really it's just problematic from the start. So we're working to fix that. Comments we're due at the beginning of November on that. So that's something we hope to work with the agency to have fixed alternatively, so we can have hair testing recognized by DOT, not require that secondary testing, and ultimately allow those to be reported to the Drug and Alcohol Clearinghouse, which is on this slide here. I mean, this is no real new news to any of you on this presentation now, but we did have the clearinghouse go in effect in January of this year. A little bit of a rocky rollout the first few weeks. In essence, the clearinghouse kind of crashed the same day it was introduced. Our friends at FMCSA don't always like to say that it went down, but it had some problems. They were great in fixing it immediately, getting that working and out there, and that's something that we're happy to see reporting and really working today. I have some slides for those of you that haven't actually been into the program itself to see. These are some screenshots. I ran a query on myself. I do have a CDL. Fortunately, it came back that there were no results in the clearinghouse. That could have been a bit embarrassing otherwise if that was a different outcome there. So where we're at today with the clearinghouse, and this is great information provided by FMCSA. They do this on a monthly basis. As of the beginning of October, it's reported usually the beginning of the month, there were 39,541 drug-related violations in the clearinghouse. So that's close to 40,000 violations that we may not have known if it was not for this clearinghouse. Alcohol violations, close to 900. Out of all the substances reported related to drugs, 40,000 have been reported. No surprise, marijuana ranks number one with 21,000 of those being reported in the clearinghouse. Return to duty, this is something that we're now focusing our attention on a little bit more. And that really is the question of how many of these drivers who have had a positive test have completed the return to duty process. Keep in mind, just because you have a positive drug test doesn't mean you can never drive a truck again. There is a return to duty process that you can go through, going to a substance abuse professional, that's the SAP, and providing that evaluation allows you to return. Of those 37,000, 3,461 are in a not prohibited status, which basically means they've completed that initial return to duty process and are eligible to return back to duty. So it'll be interesting to see how many drivers go through that process now that this is all tracked. Before, the concern was that because this data wasn't regularly available on a public website, we didn't know how many actually were going through that return to duty process. So interesting data, and we'll see where this takes us in the coming months. Related, just some medical qualifications I'm going to hit on because we have a due date coming here in June of next year. This has to do with the National Registry of Certified Medical Examiners. And this will automate the process that once a driver goes in and passes his or her medical exam, that medical examiner will automatically submit that exam to FMCSA. FMCSA will then automatically submit that information to the state driver's license agency, and we'll have that linked up with that driver's medical card or with that driver's MVR automatically. So instead of you as the motor carrier or that driver sending the med card into the state, that'll be automatic as of June 22nd of next year. So we look forward to seeing that come into place. A couple entry-level driver-related issues that I wanted to cover here very briefly. We have ELDT requirements that were supposed to go into effect February of this year. That was delayed until February of 2022, unfortunately. And what those requirements would have been were basically any new driver obtaining his or her CDL would need to go through a structured training program before they could obtain their CDL. Related to entry-level drivers, ATA continues to fight for younger drivers and allowing under 21-year-olds to operate in interstate commerce. I have this great graphic. I'm from Pennsylvania, so I'm a little bit biased for this, but currently today in 49 states, there are some version of under 21-year-old drivers allowed to operate in intrastate commerce. In PA today, an 18-year-old could drive from Erie, Pennsylvania to Philadelphia, PA, 420 miles one way. That same driver could not drive from Erie, PA into Conneaut, Ohio, 35 miles, because that's crossing state lines, that's interstate commerce, and you have to be 21. We don't think it makes a whole lot of sense that crossing state lines makes a big differentiation between whether you can be 20 years old or 21 years old. So we've pushed legislation known as the Drive Safe Act that was introduced in Congress in 2019. Would require probationary periods of training, certain number of hours, 400 total hours, which is above and beyond what is required for you to obtain your CDL at age 21 today. It would require technology requirements. It would require you to have an experienced driver with you during certain stages of the training. So again, we think it's a structured program to get drivers into our industry at an early age. FMCSA has thought so as well. They have recently enacted a military pilot program, which would allow drivers who have military experience driving CMV-related vehicles in the military to apply and be a part of this pilot program. Really, the target is reservists, because it would be folks that have had military experience but are under 21, and the primary target is folks that are in the military reserves. That program is scheduled to end in January of 2022. Just recently, we were thrilled with FMCSA announcing a non-military pilot program that would look to allow 18 to 20-year-olds to operate in interstate commerce as part of a program that is modeled very closely to the Drive Safe Act. Comments are due on that program November 9th, and we hope to see that program formally announced thereafter once FMCSA has gone through all the behind-the-scenes work in getting that put into place. So key points is we have a military program that's active, a non-military program that's been proposed that we hope to see put into place here in the very near future. And last but not least, I do like to cover a couple of the technology-related pieces. Everybody always asks about automated vehicles and are we going to even need drivers in the future? And the answer is yes. A driver's job may look differently in the future. But you have airline pilots today that are flying airplanes, but really when they're in the air monitoring instruments, doing work that you need to always have two people in the front of the plane. We think driving and commercial drivers will be very similar. FMCSA has vested time in looking at technologies that exist today that may be beneficial to motor carriers out there. So they've created a program that looks into different technologies and really provide education to motor carriers on these different technologies that exist and how carriers can adopt them. The primary focus early on is on automatic emergency braking, air disc brakes, lane departure warning systems, and video-based onboard safety monitoring systems, which are really drive cams commonly referred to. So again, with this, the goal is for ATA working with FMCSA and other industry partners to really look at what's used today, put education out there to motor carriers, so motor carriers can then, instead of being told they need to adopt these technologies, determine what's best for them and implement them as such. So with that, I know it was a bit of a mouthful in 30 minutes or so, but that's kind of the lay of the land of what we're dealing with regulatory-wise. It's certainly not all-inclusive. There's a lot of other things happening, but that's a lot of the nuts and bolts from FMCSA's perspective. My contact information is up there on the screen. Including a Twitter account, which I tend to tweet out federal updates and not selfies of me in the meals I'm eating and things like that. So feel free to follow me or reach out to me if you have any questions. And with that, I do think we do have some questions. So Thomas, sir, I will turn it back to you.
Awesome. Dan, thank you so much. And you're right, we absolutely do have a number of questions. If you haven't asked your question already, down at the bottom right, there's a Q&A section. Go ahead and put your question in there. We'll answer all of the questions that we can in the time that we have today. And then anything that we aren't able to answer, we'll reach back out to after Day with DISA. Additionally, if you'd like to download a copy of the presentation, there's a download button at the bottom right. Just go ahead and click on that button, and you'll be able to see a copy of this presentation and download a PDF of it. Dan, first question, are there any waivers or exemptions for DOT modes other than the TSA or FMCSA?
Yeah, so other DOT modes like rail, aviation, there's certainly exemptions out there. They would not be exemptions that I currently track just because we're dealing primarily with trucking. Specific to trucking, there are some hazmat related regulations that come out from PHMSA, mostly on the enforcement side and certain permits that carriers are required to carry. That's on the PHMSA side. With trucking, primarily the exemptions about there have been FMCSA, TSA, as I mentioned. And the other that's probably a good point that's not necessarily an exemption, but there's been guidance that was issued earlier on in the pandemic that basically said that truck drivers are considered essential employees and do not need to follow some of the restrictions that have been put out in certain states, such as the quarantine requirements, the 14-day quarantine requirements. Again, not necessarily an exemption, but a designation of an essential employee, and that's been Department of Homeland Security CISA guidance that was issued.
Thanks for the clarification. Are there any penalties for an organization claiming the hours of service national emergency declaration but not actually qualifying?
Yeah, so I mean, I can't give you let me back up. The answer is absolutely yes. Can't give you a monetary amount because that varies based on the violation and the circumstances. But if you were audited, say even next year, you could have an auditor in your organization, and they determined that you were declaring the emergency exemption, but you really didn't qualify for it. You can certainly be found in violation. Fines would be attached to that. Same thing could happen at a roadside inspection. I've had a couple cases come up where drivers were stopped at routine roadside inspections, and they were told, or they said they were over hours. They said, well, I'm operating under the emergency declaration. The investigator dived a little bit deeper, determined that no, they weren't, and they were put out of service. So absolutely yes.
Okay. Have you seen most FMCSA customers continue drug testing during the COVID-19 exception?
Yeah, that's a good question. My general feedback that I've received on the random drug testing is that carriers were continuing to test and hit that 50% as needed. The guidance was more along the lines of giving them an opportunity if they really did have an extreme case where they couldn't get a driver in, they were just shy of hitting that number, and I mean they have through the end of the year to hit that. That they would have it if they needed it. My general guidance to carriers has been test as if this exemption didn't exist. Just get it done. And the feedback was really interesting. We asked a lot of our folks earlier on, back in June, July timeframe, is this going to be an issue? Because we did have some calls to ask for a reduction from 50% down to 25%, which is where we were last year. And I had folks with 5,000 trucks say this isn't a problem for us, and I had folks with 5,000 trucks say, yeah, this would be helpful. So I think it's split, but I think folks are, while it may not be the most convenient to get it done, folks are going to get it done and get that number, and this can help them if needed.
Can a motor carrier still require a driver to use an ELD even if they're considered short haul?
Yeah, great question. Yes. So the hours of service changes that we saw go into effect here recently, I like to refer to them as their flexibilities. So they're not necessarily changes in the regs that carriers have to change operations around to comply with. So say back in July of 2013, we had new regulations introduced that would require carriers to really alter the way they do business. Here, these changes are more flexibilities that carriers don't absolutely have to use as long as they're complying with the underlying hours of service rules. So that short haul rule, for instance, if you operate within 150 air miles and return to your duty day within 14 hours, you're exempt from ELDs. Your carrier may say, hey, we want you to use an ELD anyways because of tracking purposes. A lot of ELDs are equipped with other back office devices from Milux, so on and so forth. So absolutely, a carrier can say yes, you'd be required to follow their rules. And as long as you're not violating any of the FMCSA rules, you're still in compliance.
You touched briefly on HOS changes there. one question that addresses that, what do you foresee as the biggest HOS impact in regards to the new changes?
So there's probably two. I'd say the number one would be the 30-minute rest break. Reason being is that was changed pretty significantly to where previously you had to take that break after 8 hours of coming on duty. So it would apply to really everybody in the industry, including local drivers, short haul, pickup, and delivery. Now the rule is written to where you only have to take that break after 8 hours of driving time have elapsed. So unless you're driving 8 straight hours, you wouldn't be required to take that break. So this is really going to target over-the-road long-haul drivers that would be going 8 straight hours without stopping. And realistically, there's going to be a lot of cases where that driver does stop for some reason, whether it's a rest break, what have you. And it might be simple tweaks to where if a driver was stopping, say, for a 15-minute rest break for their own well-being, they just extended another 15 to satisfy that 30-minute break. So I think that's probably going to be number one. Second to that would be the split sleeper. That would only apply to those that have a sleeper berth equipped cab, but that allows some flexibility with their time on that one.
Another question here, are there plans to expand the CSA preventability, crash prevention preventability program?
So the short answer is no immediate plans to expand it, but that doesn't mean that FMCSA isn't going to continue looking at this. So one of the reasons they justified their current changes to those 10 crash categories that I highlighted earlier was based on data submissions they received during the pilot program. And to FMCSA, it was what crashes do we often get challenges on that made sense, that we often were overturning and saying the driver was not preventable in that situation. That was the basis for those determinations. FMCSA said they will continue to evaluate this and add to the list if necessary. While I don't think we're going to see that in the immediate future, it could be something we see over time.
Dan, you addressed hair testing and that going to the proposed rulemaking phase. There's a couple questions on that. Do you see a lot of larger transportation companies using hair today?
We do, and primarily it has been larger companies out there that use hair testing. We've seen also some small and mid-sized companies that have adopted it just because of the results of hearing the benefits from the larger companies. So yes, our kind of concern is we're not going to have more or smaller carriers rather adopt hair testing as an option if they have that side-by-side testing requirement. So our view is if we get a rule that's favorable to industry that says you can do one or the other, we would see more smaller carriers, medium-sized carriers start utilizing it. And it really comes down to business practice in a lot of cases. To do a hair test, to pay for that hair test in addition to your DOT urinalysis test, a larger fleet might be able to afford that, whereas a fleet of 50 or 100 trucks, that might be an option that's not feasible for them.
Yeah, Dan, and I have a question. I know when you were talking about the confirmatory test being urine, you cited some of the specifics as to why that would be problematic with the detection windows. How likely is it that the HHS passes that urine or oral confirmatory test is required? And then would you still be able to take action based on a positive hair test and a negative oral fluid test or a negative urine test?
Yeah, so it's a great question. Going into these guidelines, we were under the impression, based on our feedback, that the guidelines would be suitable for trucking. We had heard concerns of this this alternative testing concept that we certainly raised concerns about. We had multiple meetings with Office of Management and Budget while this rule was being developed. And when it came out, mind you, at like 5:30 on a Friday evening, it was announced, it was not favorable. And I mean, it was a 90-some page document. And within the first paragraph of reading, I knew that this wasn't going to be good. So the great part is of the comment process that exists for rulemaking, which we were engaged in, allows you to voice that concern. So we put our plea out to carriers that use hair testing. Voice your concern, say why this is going to work, is not going to work. Talk about experiences you've had with hair testing in the past. We've done a lot of outreach on it to get folks behind the rule, and even to raise that issue of we're not going to get smaller carriers to use hair testing if they're doing the side-by-side testing. HHS and their folks there, the response was, well, 90% of hair tests typically come back negative, so that's 90% of the time you're not going to need to do a second test. While that can be true, that does not address that 10%. And to me, it's like saying, and this is an adage my folks and staff are getting sick of me saying, it's like saying 90% of the time you're in a car, you're not going to be in an accident, so don't wear a seatbelt. It doesn't address the 10% where you may be in an accident and should have a seatbelt on. Maybe that's a bad analogy, but that's mine. It's totally ignoring the concerns of the rule and focusing on the good of it. So there is good, but we want to get it fixed. We're confident that through the comment process, our voice will be heard. And if ultimately that fails, we're ready to pursue from a legislative perspective. And if litigation that comes along and we need to handle that, we'll do that as well.
Right now, hair testing isn't an option or a DOT mandated option. Will the Clearinghouse include hair testing or other non-DOT testing?
So to your point, Thomas, I mean, today you cannot report a positive hair test to the Clearinghouse because it's not DOT recognized. Under these proposed guidelines, we feel it's going to be the same way because you would have a hair test. The only way you'd be able to report that hair test is if the driver also then tested positive on that alternative specimen. Or, and this is the one that I enjoy, they said, well, if your driver admits to drug use, you can report the test then. That would lead as a positive. How many times you go to a driver and say, hey, you tested positive, and it's like, you know what, you're right, I'm doing drugs. I mean, let's be realistic on this situation. So under the proposed rules, we do not believe the DOT would be able to write a rule where that hair test would be able to be reported into the Clearinghouse. And you're going to be in the same situation you are today, where carriers, when they hire a driver, would not know of a driver's previously failed hair test.
While we're on the FMCSA Clearinghouse system, we have a question. How is the FMCSA policing the Clearinghouse system for compliance?
A great question. So for auditing purposes, it's going to be pretty easy for them to go in when they audit a carrier and first see, is that carrier registered in the Clearinghouse? And then through the running of a report, if a carrier has a driver roster, and mind you, after January 6th of next year, will have been 1 year in the Clearinghouse, everyone would have needed an annual query at that point. They'll be able to run that list to see if those queries were run compared to the driver roster, and you have simple compliance there. I do know they're doing comparisons of DOT numbers to see what carriers are registered and focusing on some of the smaller carriers, but that'll be one way they'll be able to look. I think it's going to be pretty easy for carriers to find out if they're in compliance or not.
And then I think we have time for just one more question. Even if under 21-year-old drivers were allowed to drive a CMV, would insurance companies be able to insure them?
Probably number one question I get on under 21. The answer is yes. We've talked with a number of insurance carriers early on when we started pushing for this. It said we would insure under 21-year-olds. There obviously would be stipulations that go along with it. I also add that keep in mind under 21-year-olds operate in intrastate commerce today. So you do have insurance companies out there that are insuring these drivers, and done properly, we see the marketplace expanding to where that would be no problem.
Dan Horvath, VP of Safety Policy for the American Trucking Association. Thank you so much for joining us today and sharing your knowledge with our attendees. Any last words?
I appreciate you having me today. As always, we're tracking all the safety regs coming down the pike. So while something might be true and accurate today, it could change tomorrow. So that's a great news behind our team here at ATA. They're constantly involved in it. So I do appreciate you having me today, though.
Yeah, thank you again. And again, if anyone has any other questions, drop it in the Q&A. We will reach out to everyone after Day with DISA. And if you'd like a copy of the presentation, it is available in the materials link below. Thank you again for attending.